Good evening, everyone. Please, can you all kindly confirm if you can hear me? Okay, can anyone hear me?
Yes, we can hear you.
Yes, all right. Good evening, everyone, once again. My name is Dennis Williams, and I'll be your moderator for this session. I kindly want to apologize. I kindly want to apologize for the noise in the background. I have to be in a position, in a place that is a bit noisy. But irrespective, I'll try as much as possible to minimize the noise from my end, right? And I trust that we'll be having a wonderful session this evening. Once again, welcome to class. This is the first session for intellectual property for the Q first quarter, second quarter 2024, and our topic for today is intellectual property for business. I can see some of our mentors are already here with us on call. I want to say special thank you to all of them that have joined in already. We'll be going straight into the business of today, and I'll first start with the announcements, right? So registration is still ongoing for those who are still interested in the Jiipcc mentorship and internship program. Because you can kindly let your friends and your family know that till the second week we are still open to having mentees registered for our program. And also for those who are taking who joined us through the free registration, um, we kindly want to say that you are free to make payments for the certificate, right? For those who are yet to complete their payments, please, I advise or we advise that you do so before the close of the before the end of the program. Thank you, everyone. So we'll also be going straight now into our mentors profile, right? For want of time, some of our mentors, I will just be reading a summary or giving a summary of their profile. I'm sure we sent all the flyers of our mentors to your groups, so I'm sure you guys have gone through them. You've seen or you've had the opportunity to know some of the mentors that will be mentoring in this particular session. So our first mentor for today is Miss Bernice Ofunre Asieni, right? Miss Bernice Ofue Asieni Esquire is a visionary in the field of fashion law with a multifaceted legal background and a deep commitment to excellence. Ms. Asieni has has made significant strides in the fashion industry. Her educational journey stands as a testament of her dedication to mastering her craft. Ms. Aseni's passion for fashion law took her to the prestigious Milano Fashion Institute in Milan, Italy, where she honed her expertise on an international stage. She has also earned certifications in intellectual property law from the World Intellectual Property Organization (WIPO) and Advanced Intellectual Property Evaluation from the Intellectual Property Institute. As the founder of the Cardinal Council, a leading fashion law firm in Lagos, Nigeria, Ms. Aseni has constantly demonstrated innovation and excellence. Her diverse clientele includes fashion and creative brands, startup fashion technologies companies, investors, models, and influencers. Her ability to navigate the intricate intersections of law and fashion has solidified her reputation as a trusted legal advisor within the industry. Ms. Aseni expertise encompasses various aspects of fashion law, including intellectual property rights, contract negotiation, employment law, and more. Her profound understanding of the legal framework ensures her guidance and education are tailored specifically to the fashion industry. I will not be going further with Ms. Aseni's profile. Please, you can look it up on the group if you need to know more about Ms. Aseni. Thank you so much, Ma, if you are already here with us. Sorry. Okay. Our next mentor for today is Miss Chinansa Wana. Sorry, Ma, if I didn't pronounce your second name correctly. Ms. Chinansa is a legal practitioner, consultant, and author in intellectual property, media, entertainment, and technology. She has worked with top-tier law firms like Banwo and Ihodola, Aluko and Oedipo and Jackson, Etsy and Edu. She is a recipient of several national and international intellectual property recognition and a member of notable IP associations. Thank you very much, Mrs. Chinansa, for joining us. Thank you. We'll be having you shortly, right? But before that, we'll be going ahead to read our other mentors' profile. Our third mentor for today is Miss Amosa Shukrat Modipeola. Um, Amosa Shukrat Modupeola is a proficient consultant, analyst, and educator in the field of intellectual property with public sector experience. She is a member of the World Intellectual Property Organization, WIPO committee, and has a master's degree in intellectual property at African University Zimbabwe in conjunction with WIPO and the Japan government. She has partaken in professional trainings at the partook in professional training at the World Intellectual Property Organization as well as other IP related bodies and has facilitated numerous intellectual property related programs both online and offline. Shukurat is the pioneer of an educational platform, the DIN, the Intangible Nuggets, which facilitates IP awareness and brings the knowledge of intellectual property closer to everyone. In celebration of the 2022 World IP Day, she partnered with other stakeholders to sponsor 5 IP enthusiasts and register them for WIPO Advanced course. Amosa has accredited agents at the Nigerian Intellectual Property Office, Nigerian Copyright Commission, Trademarks, Patents, and Design Registrar, and her expertise are, but not limited to trademarks, patents, um, industrial design, copyrights, and trade secrets, respectively. Thank you, Ms. Amusa, for being here. We are glad to have you amongst us. Our last but not least on our mentors list is Ms. Rita Anwire Chinda. Ms. Rita, Mrs. Rita is an intellectual property and information technology lawyer from Nigeria. In September 2021, she was listed as a leading Nigerian woman in business law by Esquire Legal Practice magazine. She won the 2021 Young Legal Professionals Award for Excellence and was listed as one of the 2020 YIPR Influential Women in IP Trailblazers. She provides advisory, advocacy, and transactional legal service to a broad spectrum of local and foreign clients. She has cognate experience in projects concerning data protection and privacy, media law, copyright, trademarks, and patents. Rita holds a master's degree in intellectual property and information technology from the University of Derby, UK. She is a member of the Nigerian Bar Association, sections of Business Law Committee and Arbitration and Alternative Dispute Resolution, Information and Communication Technology, and intellectual property member of National Institute of Management and associate member of the Chartered Institute of Arbitrators UK, Nigerian branch, the current PRO for the Port Harcourt chapter, and the PRO term secretary for the Young Members Group, the PRO of the Nigerian Bar Association Young Lawyers Forum Port Harcourt branch. Rita is a co-contributor to the 6th edition of the International Comparative Legal Guide on Data Protection 2019, and published an article with the Trademark Lawyer magazine titled How Artists Can Commercialize and Exploit Their Intellectual Property. I think I'll be stopping here for Miss Rita's profile. Right, I'm sure if you want to know more about our mentors, you can go back to your group and you can have access to their profile, or you can follow us on our social media pages, and their profiles are also there. Right. So let's get into the business of today. I can see Ms. Bennis is on call, Ms. Chinansa is on call, I can also see Miss Rita, right? So we'll just be starting from the top, right? And we'll be calling on Miss Bernice to come and give us her introduction into today's topic, IP, intellectual property for business. You're welcome. Thank you for joining us. Miss Bernice, can you hear us now? Okay, if Miss Bernice is not yet ready, I would just like to call on Miss Rita. Miss Rita, please, if you are with us, now you can go ahead and introduce the topic for today to us now.
Okay, hi everyone. Let's see. Can you hear me?
Yes, ma'am, can hear you.
Good evening, ma'am.
Good evening.
Yes, I can hear you, ma'am.
Great. Thank you for the invite. And the profile is too long and some things are a bit outdated, but I think we'll manage. So I was tasked to talk about IT for business. I don't know how many of us know of who understand how or what intellectual property is. If you do, please write in the comment. Let me know if I'll just rush through the IP elements or and then go straight to the business angle and then we'll close from there. So if you have an idea of what IP is, please let me know in the comment section. Okay, so I see nobody has commented, so I'll just move on. So basically, the long and short of IP is that IP is considered to be an intangible asset created out of human. Great, thank you, David. Thank you, Oluwasegun. Created out of human intellect that enjoys legal backing and protection from unauthorized use, commercialization, distribution. And when you bring that back, thank you, Innocent. Thank you, guys. And if you bring that back into the business angle, what that tells you at the end of the day is that for those of us in Nigeria, and also please put in the comment section, let me know what jurisdiction you are joining us from. So from these comments, from this definition, you find out that IP basically is territorial. It's only the jurisdiction that, thank you, Innocent. It's only the jurisdiction that you take the steps to protect your work. Thank you, David. That you get to enjoy all of these things that the law will definitely take you serious. Thank you. So it's more of Nigerians then. Oh, fantastic. Under IP, you have various types, but because of the business element of what we'll be talking about, we'll just focus on copyright, trademark, patents, industrial design, and trade secrets. Right. Lots of Nigerians, Oshe. So, for copyright protection, copyright definitely protects. Lovely, Oluwatoyin. Copyright protects literary and artistic works automatically, irrespective of the quality. So, if you haven't read the recent Copyright Act, please take your time to go through it and get acquainted with all of the IP laws. But that's what's going to help you understand some of the issues or things that you may come in contact with when you're dealing with IP. So under copyright, you have literal work, sound recording, broadcast, the copyright owner, exclusive rights to monetize. Oh, nice, Jess. Jenny from Rwanda, but from Liberia. Very, very lovely to meet you. Thank you. And the exclusive rights could be the right to reproduce, right to publish, distribute, communicate to the public, translation rights, adaptation rights. Now, you can choose to monetize all of this either through assignment, or you give a third party the right to monetize your work. For musical works, that will be the collective management organization. And also, I think for writers as well, and audio visuals, yes. So these three types of eligible copyrighted works can assign their right to third parties to help track how their work is made, and then they will generate revenue for them. Same with basically acts as or persons or entity that intend to commercialize the copyright in question. Now, outside the exclusive rights, we also have the licensing, and under the Nigerian Copyright Act. Apologies, I did not make reference to other jurisdictions like Liberia and Rwanda, but I promise to do better in the next presentation. But under the Nigerian Copyright Act, a licensing agreement, preferably an exclusive one, must be in writing. A non-exclusive one is usually between more than one parties, is not restrictive, while an exclusive license is restrictive. So it's just between party A and party B, whereas for non-exclusive we have multiple parties, and that gives you several sources of income at the end of the day. And in an event that someone uses your work without your consent, permission or authorization, you have the right to explore civil remedy or criminal remedy depending on your jurisdiction and what the law provides there. You also have the option of exploring alternative distribution mechanisms. Under the Nigerian Copyright Act, the law provides that the Nigerian Copyright Commission, which is the agency that regulates copyrighted works, would constitute what is called a dispute resolution board to resolve disputes on royalties, licensing, and any other thing that they deem fits with, that the agency thinks should be resolved under the dispute resolution board. I think is it under section 36 of 7 or 37 of 7, I can't remember now. It expressly states that parties can opt to arbitrate. So other than going to the Federal High Court, which has the jurisdiction to resolve your disputes, you can choose to arbitrate your dispute. Now, we're talking about arbitrating IP-related disputes for businesses. You need to understand that ADR, such as arbitration, targets huge commercial transactions. Mediation, focusing on lesser sums of commercial transactions, and then you can choose to either submit if you don't have an agreement that stipulates that in the event of a dispute, you opt to resolve your dispute that way. You can then draft a submission agreement or a mediation agreement, as the case may be. But if you have it in your clause, say a licensing agreement that is a contract for XYZ, and it has to be expressly stated what kind of dispute can be arbitrated or mediated, as the case may be. Then you have what is called, okay, that doesn't relate to business, but then you have the performance rights as well. So that's like the long and short of copyright. Then moving on to trademark. Trademark will basically protect the distinctiveness of a business brand that is capable of distinguishing the brand's goods or services. Now, under trademark, you have 45 classes, and then you pick between class 135 and class 36.5 for services, whatever it is your business is doing. Now, under the Nigerian Trademark Act, apologies, I'm referring so much to the Nigerian Trademark Act. I think it's just from Liberia, so I do apologize in advance because I'll make a reference to Nigerian law. So, under the Nigerian Trademark Act, before you register a mark, you must determine that the mark is capable of distinguishing itself and is distinctive in nature. They have different types of trademark. You have motion marks, you have 3D marks, you have color marks, smell, logo, signs, symbols. But under the Nigerian Trademark Law, Trademark Act, it doesn't really matter when it comes to color. The registry is not so particular about registering colors. So you basically just do a black and white, and then it's assumed that you are, thank you, Jess. It's assumed that you are covered for all the other colors. So ensure that you consult a trademark attorney or a trademark firm to properly guide you on what is obtainable. If you get an assignment or a license, you also have to register with the registry. You can also choose to get the opinion of the registrar as to whether the mark you want to register meets the basic requirements as stipulated under the law. Then for the procedure for trademark registration, I think that's something that businesses also fail to understand, that the fact that you have an acknowledgement or an acceptance, that doesn't mean that you have a trademark certificate. because I know a lot of people complain when you tell them about the oppositions period, which is mandatory for 2 months under the law. Afterwards, apply for a certificate and the ceiling and all of those things. Something is coming to mind, but it's, when I remember it, I'll tell you guys. Then we move on to industrial design, which protects the visual appearances of a brand or a business product, the combination of lines and colors. So this one now may apply to the manufacturing industry, fashion designers, etc., etc. Then for patents, so the requirement for industrial design is that it must be new and novel and not subject to public morality. Then for patents protects inventions that are new, novel, not obviously a skilled person, capable of industrial application, and the owner has the advantage of being granted exclusive rights to make, sell, distribute the invention for a term of period. Now, all of these IPs, copyright is between 50 to 70 years, depending on the type of eligible work. Trademark 7 years, subject to renewal. So, among all the IP, trademark can last for as long as you keep renewing and you keep using trademark. You must consistently use the mark in question for commercial purpose. In an event where you do not meet that requirement, someone can apply to the registry to cancel your registration or strike off your registration. Yeah, then trade secrets. If I'm rushing, please let me know. If you have questions, to put it in the comment section and I'll answer as I proceed. Then trade secret gives a brand a competitive edge in the market. You do not necessarily need to register, not necessarily, you cannot register a trade secret, but you need to take preventive measures to protect your mark, your invention, whatever it is your brand has. That's confidential information that gives your brand an edge in the market from espionage, from stealing, theft, whatever it is. Next up, we'll be talking about commercialization. I think someone's mic is on. Do you want to say something? Okay, so next up, we're talking about commercialization models for businesses. You have franchising, which is like a good business model for expansion. So in an event where you want to move to another jurisdiction, franchising model would be your best template. And I'll give examples in Nigeria, the likes of the KFCs, Domino's, and other brands that have a Nigerian entity here. The franchisee, who is the person that goes to meet the owner of the franchise. So there's a license to set up the entity based on the terms and conditions as provided for in the agreement. So you sign an agreement to document all of that. Then you have partnerships and alliances. For that, we look at the Fenty and Puma partnership. You have joint ventures, you have mergers and acquisition, you have for instance, the Chivita and the Five Alive. And recently, Marvin Records, M&A venture. Now, advantages of a franchise are it reduces opportunity costs, lowers the risk for the franchisee, and gives them exclusive territorial rights. Disadvantages for this is that the cost for maintaining the franchise network is usually huge. The franchisee is also now obligated to give reports and follow detailed directions and provide access to accounts, information, etc. The franchisor may be limited to fee. So because you're giving one person an exclusive territorial rights, you cannot give more than one person that right in that territory, so that there is no conflict of interest, there's no breach of contract, and also infringements. The franchisee may lose their identity to their consumers or customers, who may question the ownership of the outlets. Does this really belong to Rita, or does this belong to Reginald? All of those questions would definitely come up. I already talked about this resolution mechanism for business because of the commercial nature. So other ones will include small claim courts, ADR, mediation, negotiation, arbitration, ODR, online resolution, but in form of virtual proceedings. I think there was more of that during the pandemic because of lack of ease of movement. And then you have the cease and desist letter, you have takedown proceeding, and interestingly, under the Nigerian Copyright Act, we now have the takedown proceeding, unlike before that, there were really a specified mode for protecting online products or online brands online. Benefits of intellectual property for businesses, it provides consumers for apologies. It provides consumers with safe and authentic products, higher returns on investment. It cannot be transferred automatically. So if you're a business or you're advising a business and you know read your contract properly and your clause says you're transferring everything, that clause is going to be binding on all parties. Unless you want to go and fight it in court and claim insanity or whatever it is. So yeah, you can also explore and enjoy a multi-layered IP protection. So for trademark for your business name, logo, trademark for your business, yes. Trademark for your business, the industrial design or design right protection for the visual appearance of the products, especially if you work in the fast-moving and consumer goods industry. You also get final reward for a term of duration. It gives your brand a positive image for your business that can aid in fundraising. I think that's something that most startups tend to overlook, forgetting that IP is an integral part of whatever IPs they're doing. You can also find new business partners and raise the company value at the end of the day. Now, some of the IP issues that businesses should take note of will include packaging and labeling, trade dress related issues, IP valuation in mergers and acquisition deals, industry standard, business plan, espionage, lack of market assessment. These are things of the issues that if you do not have a proper strategy, you're going to have an issue with at the end of the day. Next, I'll talk about guides for SMEs who are considering exporting or importing. You need to choose the right IP protection at the end of the day, because the IP is considered to be a key driver of economic growth and innovation. You also need to take into consideration the AFCFTA agreements, be properly guided, know the IP protection, know that IP protection is not universal, but rather territorial in nature. Uncommon IPs that businesses don't pay attention to, such as geographical indication. We do not have a lot that's been currently worked on. Cultural expression, cultural expressions. So, for instance, GI focuses on the unique characteristics and quality of a product, such as Swiss watches, the super yellow pepper, and the likes of it. But we do not have a law that protects such products right now in Nigeria. Cultural expressions, we're losing all of that to misappropriation at the end of the day. There's another type of patent that is not so popular but is gaining ground in Nigeria, which is the utility model. It's not as stringent as patent, but the invention must be new and novel and used for incremental nature. The term of duration or protection is usually 7 to 10 years without the possibility of extension or renewal. Registration takes 6 months, is cheaper to obtain, and best for products with short shelf lives. Finally, you need to take note that you cannot hold utility model and patent registration at the same time for the same product. So at the end of the day, if you're going to be advising businesses to consider IP or take IP serious, they need to do their own due diligence. You also need to take into consideration regulatory compliance within that jurisdiction as it affects your industry. There's also the trend or current conversation on environmental, environmental, social, and governance issue as it impacts your sector. And what else? I think that's basically it. But thank you so much for listening. And if you have questions, please let me know.
Thank you so much, Ma, for that wonderful session and introduction into intellectual property for business. I want to kindly encourage our mentees to turn on their video cameras. For those who are currently here on call, please, if you can, we want to see your faces. Please turn on your video cameras, and then we'll continue with the session. Okay. We would like to call on Ms. Chinasa. I would like to call on Mrs. Chinasa to also come and give us her introduction into today's topic as we quickly as we run through the topics for today, and also wish to hear so much on the subject matter. So, Ms. Chinasa, please, if you can, would like you to join us and come and help us do justice to this topic.
Hello, can you hear me? Can you hear me?
Ma, can you hear us?
Yes, I can hear
I
you.
can hear you. Can you hear me?
I can hear you.
Okay, great. Thank you for this opportunity. Unfortunately, I'm on the road. I'm sure you can see that I have my seatbelt on and all that. I had to just park on the way to be able to take this call. So I'm going to speak quickly.
Are you here with us? Okay, it seems she has a little network issue. Okay, Miss Chinasa, are you still with us? Oh, all right. I think some of her issue is kind of bad, so we'll still be having her come help us do justice to the topic. But for now, we'll be having Miss Bennis. Miss Bennis, ma, are you here with us, ma?
Can you hear me?
Yes, we can.
Oh, okay. Okay, great. So, thank you so much for having me. So it's a pleasure being here. I think that Rita has done like justice to the foundational aspect of IP. She even touched like some secondary things. So I'll take it from a different angle so we're not repeating the same thing and to be very brief. So I take it that everybody is a law student and will become lawyers, operating with businesses and all of that. So if you would be working with businesses and you'll be discussing or helping them out with their IP, it's very, very basic. You have to either get a trademark agent, because trademark is like one of the core things you'll be dealing with. There's copyrights when it comes to entertainment and all of that, but it's like business when it comes to creative businesses. But generally, right, trademark is very core to every business. It's what they exist by. So you have to understand how it works. It's not just understanding the theory, it's also knowing how to actually trademark a business, right? A lot of people talk about IP registration and all of that, but people do not really provide that particular service because of some restrictions. But you have to know that it's either you become a trademark agent or you get an agent to work with or a lawyer that's already a trademark agent to work with. If you don't have one, you can visit the registry or talk to somebody who you think has that prior knowledge, right? So once you decide that you're going to be a trademark agent and you become accredited on the portal, you have to, of course, navigate that particular thing. And like Rita mentioned, there are different classes of trademark. But one of the things that you have to pay is that there is like a place for power of attorney between the business and yourself as a lawyer. So it's either they are going to be drafting and giving you power of attorney, giving you right to register on their behalf. So how that is done is you have to actually know how to draft a power of attorney, basically, if you're going to be doing it directly yourself, or if you're working with agent, you can handle that. But for you, that's one of the cross on that particular portal. Then coming back to businesses, right? So I talk about IP for businesses that are not directly developing their intellectual property. They rely on a third party to produce that. for instance, photography businesses are a core, I don't use the word manufacturer, but they're a core creator of IP for a lot of business. And within copyright law, giving photographers a lot of rights, you have to know how to draft set agreement that both the business and the photographer basically covers both parties. So those are like one of the things you're facing if you're dealing with businesses, because sometimes if you're working with fashion business, for instance, you have to create a lookbook, and photographers are the ones who give the creative direction of that particular thing. So you have to either have a contract that explicitly gives both parties rights, or sometimes is this me? Sometimes, photographers will insist too that they want to have rights. So depending on what, and if you want to exclude them from having rights, you have to pay higher. So if you're acting for the photographer, you're acting for the designer, or you're acting for the person really that needs that particular service, it's very important that you draft contracts, or you learn how to draft contracts that protects both parties or your clients in question. Also for events, right now, you see that when people have event businesses, you don't even have to have event business. Having events and you're trying to get vendors on your event chain, IP contract is one of the core things, because sometimes you meet couples say, I want privacy. I don't want to post my pictures. I don't want to have it in-house, right? The question of IP code, because sometimes some photographer wants to also use that for advertisement of skill and work. How do you keep them from doing that? It's very important to understand how you can draft contract, either each party or particular party that right. So I've had the opportunity to represent other people in the development part. It's very important that you understand what you are giving to your client as IP. So it's one thing to build the entire app. It's another thing also assign it to the owner. And the question always comes up, what you are assigning? There is the background technology, there's the documentation of schools who had built on brand or license from. You have to state clearly that you don't have you collected XYZ from this particular brand and you are also licensing it to them. So those are things that you have to, learn how to navigate when you're drafting, contracts. It's not just to say we hereby assign our rights in this software development app or the developed app to the person. Is for you to identify and break down what you are actually doing. So you have to understand the basic IP behind that. There is also manufacturing, education, and impact initiative. People don't really talk about IP in those regards. It's when you have an event, if you have a client that has an event company, for instance, let's say the Fashion Law and Business Conference, how do you identify their IP? Of course, you understand their name, right? So the name of the event is their IP, so to speak. So sometimes you see that there's a case where IP sued because they wanted to do something similar to Lagos Fashion Week, but they claim that they have the same name. How that ended, I can't remember. But those are the things you have to account for people who are, in creative businesses like that, event businesses. You have to identify those kind of things. They also have NGOs and impact initiative. Usually, those people are not exactly in business, but they're structure. They are an organization. They are doing something, and they also want to have of their name and what they are doing. It's very important that we identify what their IP is. They have different initiatives, their impact solutions that they will want to own. For instance, let's say as trying to an example, just think about any NGO that you have, and then they have, let's say, our tech industry, for instance, where they use I'm trying to remember this popular tech for females. There are a lot of tech initiative for girls. She codes different things, right? So they have those initiatives and their organization. They might have different events that they organize. It's very important that you also help them identify those IPs that they have, because people come up with these initiatives every now and then, right? So why they are not exactly a business per se, they are non-profits, but they also have intellectual property to protect because they also want to be sustainable and outlive. So it's important they protect it. So those are like the areas that I think, or I believe that IP also comes to play. Those are like my introductory speech.
All right. Thank you, Ms. Bennis. Thank you so much for also elaborating, giving light, or shedding more light on the topic of sociality. We'd like to have also, okay, I can see Ms. Anusa Shukurat is with us. Please, now, I would like to ask before if Ms. Chinasa can still join us, we'll still have her, but for the meantime, we'd like to have Ms. Anusa to also come and tell us, or just further explain what IP for business is. Thank you, ma'am.
Hi, hello everyone. Good evening. Can you hear me?
Yes, we can.
Okay. So permit me to share my screen so I can just take us briefly. I think all the speakers have done quite well. I came in when Rita was speaking and I heard Ms. Chinasa spoke as well, but I think she had network issues and I heard Benis. So I think I'm just going to go about the I won't look at the law aspect actually. So because we are trying to encourage people to talk about IP or people to go into the IP field, especially those that are not even lawyers. So I'll be coming from a perspective of non-lawyers being able to be IP practitioners as well. So have it at the back of your mind that IP is not just for lawyers alone. Do we have any non-law students on the session? Or is it just lawyers we have here? Moderator, do we have any non-lawyer?
I think we do, but I'm not very sure.
Okay. So I'll be looking at the perspective of IP vis-a-vis other disciplines, right? So like I said, intellectual property is a way of life. Everything we do has an aspect of IP to it, right? So it's not just about law, and law, though we have these laws guiding and regulating how we use these IPs and how people can make money from it. So from this first image, you can see like some people interacting, just like I telling Benis, oh, no, let me use Benis. Like I telling just somebody that, oh, look at this phone, I made this. And the person collected it and was like, oh, you made this. And before I knew it, the person ran with my idea, right? So because I don't have any documentation of my idea, I can't even protect it. So the person was able to take my idea and run with it. And if I'm fortunate, I'll be able to catch the person and, and put in the necessary enforcement measure if I can do any. So to some extent, we all know that the inventors of machine, authors of books, and writers of music somehow usually own their work. The fact that you write something means you own it. You wrote it from your own mind or from your own brain, from your intellect, so you own it. However, from this ownership, there are certain consequences that follow suit whenever you sell, copy, or use their work without permission. So it's just like how we treat our tangible property. So before I go ahead, I read through the slides and I don't think I saw anyone talk about the aspect of property. So let me talk about it briefly. When we say intellectual property, the word intellectual property is coined from two words, intellect and property, right? So the property of your intellect, that's intellectual property. And when we talk about property, we have tangible property and intangible property. Now, tangible property are this type of property that we can carry around. You can see them, you can move them, you can feel them. On the other hand, we have other types of property, which are intangible property that you cannot see. You cannot move. They are there, right? But they are intangible, but they are actually there. Now, when we talk about intangible property or intangible assets, it's not limited to just IP, because we also classify goodwill, customer reputation, service delivery. We also classify them as intangible assets. However, the law has given recognition to intellectual property as a type of intangible asset. So we can't say that all intangible assets are intellectual property. No, not all intangible assets are intellectual property. However, all intellectual property are intangible assets because all these are our intellectual property, be it trademark, copyright, patent, GI, TK, biogenetics, and so on and so forth. They are all intangible assets. But on the other hand, these other types of intangible assets, such as goodwill, customer reputation, service delivery, and so on, they are also intangible assets, but they are not intellectual property. So when you're talking about intangible assets, don't just mix all intangible assets as intellectual property. So just to clarify that. So what I was trying to say now is, yes, just like you have a tangible asset, if you have a phone, if your friend wants to use your phone, they need to seek permission before they can use it. It applies the same way with your intangible assets. You have a work somewhere that you've created, someone wants to use it, then they need to seek permission from you before they can use it. And whenever they are using this intellectual property, then there's a particular royalty or benefit that comes to you as the author or as the creator of that particular work. So thus, each time we buy such protected item, a part of what they get paid goes back to the owner as recompense for their time, money, effort they put in the creation of that work. So intellectual property, like I said, is the combination of intellect and property. I can give out this slide if you want it. So the owner of the property is free to use it. You can provided the use is not against the law, and he or she also has the right to exclude others from using the property without authorization. So IP basically is referred to as the product of human intellect that the law protects from unauthorized use or exploitation by third parties. It is a category of property that include intangible creation of human intellect, owned and legally protected by its proprietors or holders. Now, the next question you're going to ask me is, so who are these proprietors? Who are these holders? It is you, I, Rita, Bernice, everybody that has come up with something intangible. As long as you've been able to create something from your intellect and you can actually put it down on paper, or you can actually put it somewhere in a fixed medium, you have created an intellectual property. So a writer, a singer, even boxers. Just some weeks back, we heard that The Rock now has ownership to his trademark, The Rock. Yeah. So fashion designers, they all have intellectual property in whatever it is they have created, and so they are the proprietors of this intellectual property. So now the first thing you need to do, we're talking about intellectual property for businesses. So I'm talking from the business perspective. You want to go into a business, so probably you are into a business and you want to actually, like we said IP foster creativity, and it also recompenses proprietors for the money, the effort, and all they've put into it. So yes, you've opened a business. Before you open that business, you spend so much money and all, with the hope that by the time your business starts growing, your IP is going to make all those money back for you. But the first thing you have to do is, how do you even know you have an IP if you are not able to identify it, right? So the first thing you need to do is to be able to identify the creations of your mind. So like I said, you have created something from your intellect and you wonder what type of intangible creation is it. So now we have categories of intellectual property. I'm not sure I saw anybody itemize this in their presentation. So when I say on a larger scale, on a broader view, intellectual property is broadly classified into two. We have the industrial property and we have copyright. So when you talk about industrial property, that's when you talk about patent, trademark, industrial design, trade secret, geographical indication, TK, biogenetics, and so on and so forth. Then under copyright, we now have related rights under copyright. So to start with, like I said, you need to be able to, first of all, identify your intellectual property. And this is where the knowledge of intellectual property comes in. Because if you don't have the knowledge, how are you able to identify this intellectual property, right? So let's dive into understanding this kind of IP so you can now identify it. So firstly, let's look at trademark. Trademark is any sign capable of identifying the goods and services of one enterprise and distinguishing it from that of the competitors. So when you see JIIPC, what comes to your mind? I'm very sure majority don't even know the full meaning of JIIPC, right? But when you see JIIPC, the first thing that comes to your mind is intellectual property, energy law, business law, entertainment law, this and that. Then Juliana Imam. Some people might not even know Juliana. You might not even know who is the organizers. But what comes to your mind is just education, training. That's JIIPC. When you see the WIPO logo, what comes to your mind? IP. When you see MTN, what comes to your mind? Telecommunications. When you see Benny's, what comes to your mind? Fashion law. When you see Rita, what comes to your mind? IP series, IP podcast. That's what comes to your mind. You necessarily don't have to know who is behind this business. But when you see the trademark speaks for the business. Okay, so we have some examples here. Look at this Burger King. When you see this trademark, what comes to your mind is Burger King. And there was a case, I think some times ago, of Burger King. If I tell you that in Australia, Burger King don't own the trademark to Burger King because somebody in Australia registered the name Burger King before Burger King could actually register the trademark. So what they use is Big Jack. Big Jack is the trademark they use in Australia because they couldn't get that exclusive right to Burger King because somebody else has registered it before they could actually register it. So look at this Apple trademark. When you look at this Apple logo, what comes to your mind? Does the Apple font comes to your mind? This logo, what does it depict? Does it depict the Apple logo? So if you should get an iPhone and what you find on it is this Apple that you can see here, do you think, or are you going to complain, or are you going to say, okay, fine, this is the real iPhone I have bought? The answer will be no, because there is no, I can't see any aspect of where this Apple was beaten. And you should know that that is the actual trademark of Apple. So even despite the fact that the Apple Telecom, the Apple INC company, the trademark is Apple, their trademark is not the main apple that we eat, right? There's a particular cutout in it that gives it that distinctiveness, and you are able to distinguish the Apple brand from ordinary apple. Now, what can be trademarked? I know Rita already mentioned this, so I'm just going to run through it briefly. What exactly can you trademark? The Coca-Cola bottle. You see that figure 8 shape of the Coca-Cola bottle? There is a trademark for that. And if you notice, you realize that no other bottling company or company producing drink use that particular bottle to promote or manufacture their own product. Is limited to just Coca-Cola because they have a trademark for that shape. So trademark protects shape, name, symbol, slogan, color, logo type, sound mark, smell mark, and so on and so forth. But for this class, I'm going to limit it to shapes, name, symbol, and logo. Yes, we protect color in Nigeria, but it's not so strong. Then when it comes to smell mark, for example, Play-Doh. Play-Doh has a very distinctive smell when you smell it. We also have sound mark, the Nokia tone, or the one that does the connecting people when you put on your Nokia phone. Those are sound mark. But in Nigeria, we don't protect non-traditional marks now. So what we are just limited to is the traditional marks like the shape, the logo, the symbol, the slogan, and color to some extent, yes. So let's look at these aspects of trademark. I'm sorry. I know Rita took us through the fact that we have 45 trademark classes, so I'm not really going to go into that. But as a business owner, you should understand that when you want to register a trademark, there are some criteria for registration. And I know Rita mentioned it. Number one, your mark has to be distinctive. And when I mean distinctive in the sense that it is not descriptive. It is not giving out what your business is doing. It is not deceptive. You are not trying to say you are selling original leather, meanwhile you're selling fake leather. It shouldn't be deceptive. Number three, it should not violate public morality. And number 4, your mark should not be generic, because as soon as your mark becomes generic, it stops doing that work your trademark is supposed to do, which is the identification and distinguishing your brand in the marketplace. So the moment your brand becomes generic, you have that possibility, or there's every possibility for that mark to be taken out of the trademark registry. So you have to try as much as possible not to let your mark become generic. And if you've noticed, you see that some companies now put in so much effort to let people know that this is our brand name. It is not a generic mark. Don't call our tissue paper Rose, or don't call all tissue paper Rose, because Rose is a brand name. We have software, is it software they call it? Software, and so on and so forth. So those are the names. Don't say Indomie generally. Every noodles have their own name. So you have to try as much as possible not to make your brand generic. So let's come to this issue of identification. How do you identify TM, SM, and R? At what point can you use it? If you realize, you see that you see some brands, and at the top right corner, you will see some people who put TM, some people put SM, some people put R. So what does this mean? When you see TM basically means this trademark is not registered, or I am in the process of registration. So what this means is that I don't have a certificate that confirms trademark registration to my brand, or it's just saying, oh, I intend to register this mark, just telling the public. But that doesn't give you any guarantee that you own that mark, because somebody else can still go ahead to register your mark despite the fact that you have a TM on it, because TM doesn't give you any guarantee. So TM majorly speaks for goods. And like Krista said, we have 45 trademark classes. Class 1 to class 34 is for goods, while class 35 to class 45 is for services. So let's say someone that is into fashion designing, you sew clothes and you sell caps and so on and so forth. As long as it's fashion, you should be looking at registering your brand under class 25, because that is the class for goods. Now, let's now assume you offer services, you do training under this same fashion designing. Now, this training cannot be classified under goods. It will be classified under services. Now, you'll be looking at class 41. So you need to understand the class your business falls under, because your mark is only protected in the class you are registered in. So if you register your mark in the wrong class, you probably might not be able to sue for infringement, because you are registered in the wrong class. So SM basically is unregistered service mark as well. So you are offering services, you probably might use SM. However, either if you are offering services or you are producing goods, TM works for both TM and SM. You can use TM for both. But when it comes to R basically is for registered trademark. Registered in the sense that you've registered this trademark and you have your certificate. You've registered up to the point of certificate. That is when you can use R. So if your trademark is not registered and you don't have certificates and you are using R, then that is illegal, because you are not supposed to use R when your trademark is not registered. So we move on to the next slide. So let's talk about patents. I think group 1 spoke about patents and trademark, and we had group 2 presentation on copyright and industrial design. So let's look at patent briefly. What is patent? Patent, I usually say patent is like an exclusive right granted for an invention which provides a new way of doing something or solves a technical problem. Before you can get a patent for something, that thing must, number 1, it has to be new, or it provides a new way of doing something, or maybe it solves a technical problem, or probably it is an upgrade of what has been on ground before, but it must solve a problem. If your patent is not solving any problem, then you can't get a patent for it. So I like to use this definition, and I say patent is like a trade by barter between myself as an inventor and the government. So I tell the government, hey, look, government, I have this perfect solution to this particular problem that we are facing. And the government is like, oh, really? And I'm like, yes. And I'm like, okay, so what will you do? What will you do to protect my invention or this my idea? And the government says, okay, draft this particular application, put in everything you have about this idea, how it's going to solve this solution, and send in your patent application. In return, we as a government, we are going to give you 20 years protection period to protect this your invention. But on one condition, you as the inventor, you must disclose everything about this invention, so that when your 20 years protection period lapses, that invention will go to the public domain and somebody else can pick up that invention, look at it, and probably work on it and come up with an upgraded version of it to protect something else, right? And like we know, patent is not just for only the proprietors. Patent protects both the private rights and the public rights. So as your patent is protecting you as a proprietor, then it also has its own benefit to the society. Like we said, it fosters creativity and it encourages innovation. So if you are not, so if you don't disclose all the aspects of your invention, how will people grow? How will technology grow? Because most of the information you need, they are on patent. And we ask people, what do people actually even do with patent public domain? Do people use patent public domain? Because in patent public domain, you get so many information. You know what is on ground. How can you develop this particular thing? How can you improve it and get your own patent as well? So not to cut the story short, what you just have to know about patent is that it's an exclusive right. And it is granted for an invention. Now, when we say invention, it does not have to do with only battery, cars, hydrogen, and so on and so forth. It could be something as simple as putting a straw inside bottled water. As long as, number one, it is novel, that is new, it is inventive, it is not obvious. And number three, it is industrially applicable, because you don't expect the government to grant you 20 years protection period for something that is not useful to the society, something that you cannot manufacture. You can't reproduce it in bulk. So basically, patent protects products, process, and equipment, as long as it is new, inventive, and industrially applicable. So let's move to industrial design. Industrial designs, okay, I think I'm just going to correct this notion. I saw under the, I saw in one of the presentations, you have types of patents. And under your types of patents, you have utility patent and you have industrial design. So I don't know where you got your presentation from, but when we talk about intellectual property generally now, IP is territorial in nature. So you should understand the terms that applies to the jurisdiction you are based in. In Nigeria, we don't call patent utility patent or utility, let me put it that way. We call patent patent. We call industrial design, not design patent. But if you are looking at the US, they call their own patent utility. They call their industrial design patent. So sometimes when we now talk about patent having utility patent and industrial design, you kind of mix it up, because utility patent is like a smaller patent. Utility patent doesn't require that inventiveness that you will find in the main patent, right? But you can actually get patent protection, but the protection period is limited compared to main patent. So in Nigeria, we don't call our patents utility, and we don't call industrial design patent. So you have to be you have to understand the jurisdiction you are in. Also, we don't classify plant patents as a type of patent, because based on our own patent law, we say that plants and animals are not patentable. So we now have a different body which is that protects anything under plant breeding and so on and so forth, which is the plant patent. But it is not, we really don't call it a type of patent, because under our patent law, we say that plants and animals are not patentable. So just to clarify that. So industrial design are exclusive rights granted for aesthetics or ornamental design applied to physical products that are to be manufactured by mass production. Basically, what industrial design does is it protects aesthetics. How beautiful is this thing? Oh, I love this car. Why? It has big bum. It has small light. It has big light. They are all aesthetics. Industrial design has nothing to do with the technicality or the functionality. It is just the aesthetics, how beautiful it is. Oh, I love this iPhone 15. It's sleek and this, yes, that's industrial design. Oh, I love this, it's small. I just like the style, is handy, is this and that, just aesthetic, basically. That's industrial design. And if you ask, how does industrial design add to business in IP? Take, for example, now, like I said, that Coca-Cola bottle is also something that can be protected under industrial design. But as a business owner, you need to look at most of these IP because some of them overlap. So you look at which one exactly will benefit my business. Which one should I go for? If Coca-Cola had gone for industrial design protection for the shape of their bottle, by now, everybody will be using that bottle design to produce their own drink, right? But because trademark will last initially for 7 years and 14 years consecutively, then when you keep on using it and maintaining it, you can use it indefinitely. That is a better protection for Coca-Cola. But let's assume you are in a fast-moving industry, like maybe fashion. You might decide to do industrial design, just protect it initially 5 years, then 2 years consecutively, then 5 years consecutively, 2 times. So all in total, you have 15 years protection period for industrial design. Once that 15-year lapses, your design goes into the public domain and anybody can use it. So if you're in a fast-moving industry like fashion, tech, and so on, you can decide to just do industrial design protection. Once your 15 years lapse, it goes to the public domain, you come up with a new design, you protect it again, and you keep going that way. But if you're in a slow-paced business like Coca-Cola is now, they don't change their bottle like that. It's just slight difference. They just improve it a bit. Then they use trademark because of the protection period for trademark is more beneficial compared to industrial design. So you need to look at your business strategy, look at the business environment, look at whatever it is you are doing. So you are able to identify the type of IP. And when you now identify, you are able to see, okay, this is the one that works best for my business. Let me see what to do to this one. Which protection measure should I go for? Should I do unregistered IP? Should I do registered IP? So all of these things are the things you need to look into when you're doing your intellectual property for your business. And you have to go along with your business strategy as well. While you are planning your business strategy, also plan your IP strategy so as to know when to enter the market, how you want to commercialize, and so on and so forth. So what can you protect under industrial design? Lines and patterns, 3D objects, shapes, packaging, and so on and so forth. If you look at all these designs, all these examples now, you see that one distinct thing about them is the aesthetics, how beautiful they are, not the functionality or the technicality, but the aesthetics, basically. So trade secrets, it refers to confidential information that gives the proprietor a competitive edge over its competitors. It could be a formula for chemical compound, process of manufacturing, method of preservation, compilation of information, etc. As long as it gives you competitive edge, it has that potential of being a trade secret. And before you can actually say something is a trade secret, it must actually do these things. Such secret must have economic value to its proprietor. It must be known only to a limited number of people, and you must have put in reasonable steps to make sure that this secret information is kept secret. And some example, we have the secret recipe of Coca-Cola, KFC secret blend of 11's herbs and spice, the Google search algorithms. All these are protected by trade secrets. But when it comes to trade secrets, you cannot register trade secrets. But what you can do is find a way, find a very good protection measure that works for your company. It could be non-disclosure agreement, it could be non-complete clause. Just make sure you have a way to protect your trade secrets. Then, like I said, how can you protect it? NDA is that you keep quiet or you sign a non-compete clause. Then for copyright, I think Rita spoke extensively on copyright. Copyright is a type of intellectual property that protects original work of authorship fixed in a medium. So I wanted to take note of two things: originality and fixation. You need those two things before your work can actually be said to be a copyrighted work, or before it can qualify for copyright protection. It has to be original and fixed. And these are examples of works that can enjoy copyright protection. Sound recording, literary work, musical works, artistic work, audiovisual work, and broadcast. So if you have any work that falls under these 6 categories, then it actually has that potential to be copyrighted. And what are these rights afforded to copyright owners? Reproduction rights, distribution, translation, adaptation, public performance, and broadcast. So protection period, trademark, for the first 7 years, then 14 years consecutively. And if you keep using and maintaining, it can last indefinitely. But that is in Nigeria. Like I said, IP is territorial in nature. When you go to some other countries, their law says 10 years, not 7 like we have in Nigeria. So it's dependent on the law of your jurisdiction. For copyright, copyright says throughout the lifetime of the author and 70 years after the death of the author. In some other countries, it is throughout the lifetime of the author and 50 years. In some other countries, it's 105 years, some other countries, 102 years, depending on jurisdiction. Patent is 20 years from the filing date. The date you filed the application, your 20 years starts reading. The industrial design, I said 5 years initially, then 5 years again, 2 times. So all in total, 15 years. So I'm going to round up with this intellectual property life cycle. Like I said, the first thing you have to do is you identify your IP. When you identify, you need to create it. When you create it, you protect it. When you protect it, you police it. When you police it, you enforce. When you enforce, you monetize. And when you're able to monetize, make sure you renew when needed as soon as possible so that you don't relinquish the right to your IP because you didn't renew. So I think I'm going to stop there. Thank you for listening.
Thank you so much, Ms. Amusa. Thank you for bringing justice to this particular subject matter. Gave us a run through everything that we need to know as pertaining intellectual property. We are very, very grateful. All right, we'll just be going straight and we'll be having the presentations from the mentees. Please, I want the group presenter for one to come up and make presentation. The time for presentation is 7 minutes. We'd like to have that very quick so that we can have feedbacks from our mentors. So please, can our group one presenter come up and make presentations for this group? Who is presenting for group one? If the group one presenter is not ready, please can group two presenter come up and make presentation? Okay, Oluwa Shegun, please, your hands are raised. Are you the presenter?
Yes, sir, I am. Can we hear me?
Yes, please go ahead and carry on.
All right. Good evening, ma'am. Good evening, sir. Good evening to everyone. I hope you can all hear me clearly.
Yes, you can.
So, from the group 2, we are basically discussing intellectual property rights, copyright, industrial designs, and trade secrets. Their benefits. So I'll be sharing my screen. Hello, can anyone hear me?
Yes, we can hear you.
I can hear you.
Okay. I was saying that, can we see the screen?
Yeah, your screen is visible.
Yes,
Please go
please
ahead with
go
the
on.
presentation.
All right. We're discussing intellectual property rights for businesses, and we started on discussing copyright. Basically, copyright has already been explained by our teachers. It's the right to use a particular product. Basically, we find it as the right to copy in a sense that is an exclusive and assignable right to use a product like the way we already explained, and product in mind that is given to the original owner of the product. So it is exclusive to the original owner except it is assigned to another person. So aside, without the permission of the owner, a copyright product cannot be used, cannot be published, can't be done, performed or anything. And we also discussed on industrial design, which has been explained, and it has to do with the appearance of the product also. The appearance, and the example we have on this slide is Coca-Cola. Coca-Cola being the shape of the bottle, the way it looks. Another example that I would say is TM Lewin, the shirt brand. I don't know if we are all familiar with that. The shirt brand of TM Lewin. There's this design they have on their brands. So that kind of thing. So it's basically any appearance, any design, shape, color, or something that is used by a particular, usually used by brands as a way of defining who this product it has to do with this particular brand, like the shape of the Coca-Cola bottle in this case. And we discussed the reason, the point of protecting copyright, like how does one go about the protection of copyright. Most of these things have already been explained in the lecture today, but just for emphasis, the Copyright Act, the Nigerian Copyright Act, which came into law in 2022, defined under Section 5 the different works that can be protected by copyright, which is literary work, musical work, artistic work, audio visuals, broadcast, sound recordings, and the requirement for such works should be given the privilege of being protected by copyright is just two. One is that it is an original creation, and the second is that it is in a fixed medium. So it has to be an original creation, and it must be in a place that can be seen and identified. And an example we went across, we had two examples of people who use their copyright and gain from it, and those that did not do it. And we have MTN. There was a time MTN was sued by the Nigerian Music Copyright Commission for using their musical works in their streaming platform. And the court eventually ruled in favor of the Music Copyright Commission. Now, it would have been a different case if the MTN had sought permission, but that just shows how much having your copyright registered does for you as a business. And another example of copyright that didn't end well is the Flappy Bird. It was a game that was created by a developer, and along the line, it became quite popular, and then people started imitating it. We had cases of piracy and things like that. But due to the fact that the person that originally created it, he didn't even try to file for copyright protection or do anything like a legal action to protect his copyright, the revenue because it was meant to get from it dropped as a result. And there are other examples. We have the recent case of the movie Tribe of Judah and Malaika by the popular actresses in Nigeria, where the case of piracy started affecting the revenue they expected to get from such movies. And then we also talked about the protection of industrial design, which in a way it also protects the brand provides exclusive right to use such design. It helps with marketing and commercialization, and that generates revenue. So when that particular product is known using that kind of design, no other company can use it without their permission. And that is where if any other company wants to use that kind of thing, the kind of agreement has to be made that will benefit the company. So that is one way they can also generate revenue. And now we also talked about intellectual property management. And in short, intellectual property management, as it says, is a way of managing intellectual property. It's basically how companies or organizations, businesses in this case, like identify and structure how they use their intellectual property. So it's a system that helps them manage their intangible assets. And the benefit is because it helps provide information about their intellectual property. When a business has a clear description of, they are able to know about it, provide information where needed, defend it, enforce it, and also place policies that will protect it, like for preparing contracts and all. So those are the importance of intellectual property management. And an example is the IBM, the International Business Machine, the IT corporation is quite popular and it is known to have over 10,000 patents granted for several years. And they don't only protect the IBM's innovation, but it's also a way of making sure that any company that would want to use any of its products has to come to it. So we have licensing agreement and things like that, which come back to it as 2019, they reported 1.8 billion as pre-tax income from just the intellectual property and intellectual property management is one thing. What about how do we know the worth of the intellectual property we are managing itself? And that is where IP assessment and valuation comes in. In a nutshell, IP assessment and valuation is a kind of it's an estimation of the value of an IP. So for businesses, say for example, Coca-Cola, the industrial design of Coca-Cola, the shape of the bottle, what is this worth? What is it worth? Or any kind of IP itself, if it's a trademark, if it's a patent, what is the patent worth? Basically trying to quantify the IP itself. So it's the process of determining the value of the asset, whether it's patent, trademarks, copyright, or trade secret. And one of the purposes for doing it is it helps one seek funding, it helps businesses in determining if their value, if it ever comes to cases of selling or merging of businesses are able to determine their value by including their IP because it also constitutes part of their financial assets, even though intangible. The IP is now IP like a bank. I can't remember the exact things. I'm so sorry. That a bank now accepts IP as a form of collateral for granting loans. There is a bank now. I think it's somewhere in England that accepts IP as a form of collateral for granting loans. And so we have Microsoft. Microsoft is an
So please, can anyone hear me? Can everyone hear me? Yes. Okay. Sorry. Sorry, my network kind of disconnected, so I'm very sorry about that. I didn't know when the presenter was presenting. All right, please can group one presenter come and make their presentation for group one so that we can go ahead with or continue with the rest of the class. Okay, please, if the presenter is not ready, can the backup presenter come up? Presentations are a very important part of our class for the mentees. The mentees' presentations are very, very important. So please, if the backup presenter is available, let's group them come and make their presentation. Okay, thank you, Mr. David.
Can you hear me?
Okay, good evening, everybody. Can you hear me?
Yes, we can hear you.
Okay.
Still on the
Can
presentation,
you see
my
my screen?
colleague.
I'm trying to share my screen.
Yes, we can see your screen.
Okay, perfect. So we're supposed to start first, but I was trying to share my screen earlier and it didn't pop up.
Hello.
Go straight into somebody's trying to speak. Is someone trying to speak? I heard somebody say hello.
No, please, you can go ahead.
Okay, so first I'll start with what intellectual property is. Intellectual property simply means original creations, inventions, literary and artistic works. Basically, intellectual property are products of the mind, products of research, products of creativity, and this is rewarded by protection by under law. So for different types of products of creation, research, we have different forms of intellectual property protection. So we have patents, copyrights, trademarks, industrial designs, trade secrets, and each of these protects different forms of intellectual property. Depending on the type of intellectual property you're dealing with, you'd fall under one or a number of the different types of protections. So the types of intellectual property include patents, trademark, copyrights, trade secrets, and industrial designs. We'll be dealing with patents and trademarks. So patents grant an exclusive rights for invention. So in case where somebody has an invention, let's say I invent an air conditioner, for example, I would have to patent both the technology in it as well as the design, that is the hardware, the external part of my invention. So for that invention to need to be patented, depending on the country where you patent your or where you register for a patent, you're given an exclusive number of years to exploit your invention. So for a prescribed number of years, you'll be the only one exploiting that invention, that is selling it as well as using the image or design for your invention. A clear example of patents is the case between Apple and Samsung, two of the biggest smartphone producers in the world. In their numerous battle over design and over technology, especially in the smartphone business, Apple sued Samsung for copying some of its design for some of its products, some of the products in its line, and they got as high as $1.5 billion damages in 2012, even though this was later reduced to $533 million. So that's how important patents are, both the technologies and the hardware of every invention is patented by people that invested in research as well as people that invested in the production of the invention. There are different types of patents: utility patent, design patents, plant patent. As our mentor corrected earlier, in Nigeria, patent is patent. So these might not apply in Nigeria, but in other climes, there are different types of patents. From utility patent, which refers to patent for the functional aspect of a product. Let's say, for instance, you have an air conditioner, and the technology you have within the air conditioner helps kill mosquitoes and at the same time provides cooling for whatever area it is turned on. That part of your invention will be protected under a utility patent. Then for design patent, it refers to the appearance, for instance, the shape, configuration of the object. So for instance, I give the example of the air conditioner again. The outward appearance of the air conditioner, for example, would be protected under design patents. For plant patent, this applies more to scientific um, experiments as well as research that leads to maybe new plants being developed in the lab. So for these type of plants, they would fall under, they'll be protected under plant patents. What are the advantages of registration of your patents? So one of the advantages is exclusive use. As I said earlier, depending on the country where you register, for a prescribed number of years, for instance, in Nigeria, 20 years, you have exclusive use of your design and your invention for that number of years. You also have unique sales. So in exploiting your invention, you'll be the only one selling that product with that appearance and with that technology for the duration of your patents. Another advantage of registering your patents is royalties. So a good source of income for persons that devote their time into research and development of new ideas and inventions is that they could get royalties. So you could get royalties from maybe licensing or franchises. So in this instance, you give permission to someone else to sell the product for you or to manufacture the product in another part of the world for you. And in this, for this, the person pays you an amount of money every year or a percentage of sales at every time that product is sold, the holder of the registered patent gets a cut from it. Another advantage of registration of royalties is that it attracts investors. So we all know that some companies start out as small companies, but later upscale into being bigger companies. So if you start out as a small company, um, and you probably want to attract more investors to invest into your company, it will be important for them to know that the product they are investing in is protected by patent and that you own it. So in that sense, investors will not invest in a company where maybe the unique selling point of that company is the product designed and then the product designed and invented is not protected. In that sense, investors would not want to invest in that type of company or would prefer that whatever technology is first registered and has a patent before they invest. Registration of patent also encourages innovations. Patent registration has the effect on companies. Employees in companies devote their time and their energies into research and development of every product that we see out there. And part of the motivators or part of the motivation for them to keep working is knowing that they are not working for somebody else to reap the benefits of. They're working to increase revenue of the company and in the same way increase their own earnings as well. It also increases brand value. Yes, it's important to patent your inventions because in fact intellectual property and patents as well as other forms of intellectual property protections increase brand value. A brand that has all their trademarks, patents, industrial designs or trade secrets well protected has better value. And I'm sure we all know about IP valuations. So in depending on the type of company you work for, depending on the type of products you're working on, there are valuers that value how much your intellectual property is worth. Now, if your intellectual property is not protected, then whatever you're doing cannot be valued and it reduces the value of your brand. Maybe in case of maybe somebody trying to invest in your company or probably buy your company, or in a case where you're trying to take your company public. Moving on to trademarks. Trademarks include symbols or words legally registered and established by use as representing a company or product. Trademark could include words, symbols, marks, and for each of these, they are protected under the law. So I'll give an example of a trademark. Good example of a trademark is Nike and the check mark on Nike. That's a symbol. But wherever you see that symbol, you affiliate it to Nike because it's a registered trademark. And Nike is the only one that uses that check mark on their products. According to Section 67 of the Trademark Act, it includes devices, brand, heading, label, ticket, names, signature, word, letters, numeral, or combination of any of these. Why do businesses need to protect their trademarks? Legal protection, that's one of them. Protecting your trademark protects you and your business from third-party infringement or other persons trying to exploit the value you've invested into your brand. So you have protection. You can apply to courts. You can first protest to the registry, trademark registry, or trademark office, depending on your country, flagging that someone is trying to take a name that you've registered before. Usually after trademark applications, acknowledgements, trademark registries or trademark offices usually publish in the trademark journals, the trademarks that are published per time. And there's usually a window for registered trademarks to protest or to indicate where they perceive that there's a potential infringement by another company, so or another person. So you have legal protection from other third parties using your trademark. It also builds value. Now, because businesses invest a lot into their branding and their marketing, and as well as the quality of their products, all of that goes into their names, their mark, or their symbols that represent their goods. Because for their customers, wherever they see those symbols and their goods, it reminds them of the value of the product as well as the quality of the product. So it's important for companies and individuals in business to protect their trademark. It also guards against future expenses. So in a situation where you've been building a company or selling a product for a number of years, if your brand name isn't protected, somebody else can easily take your name, your mark, and at the same time your reputation of goodwill, and then you have to start afresh. In this sense, you've lost all the years that you've invested in your brand and your product, and nobody wants that. So if you don't want that to happen, it's important that you protect your trademark. It also gives you I'm sure there are more protections here, more advantages and reasons why. There's also licensing. So trademarks, you're able to license your trademarks for someone else to use them. So trademark is also an asset, just like you have your house, your gadgets, your devices. Your trademark is also an asset. In that sense, you can also license it to somebody else to use it, probably in a different country or in a different jurisdiction. It's actually a good way to break into new markets for companies or products that are limited to a particular geographical location. Licensing their trademarks is also a good way of earning revenue as well as spreading and widening their reach. There are examples of popular trademarks here. We have the Volkswagen trademark and Coca-Cola trademark and logo. Wherever you see these, what it reminds you of, where you see the mark to your left, it reminds you of the car Volkswagen, and you don't need to see Volkswagen being written out plainly to know that that's a Volkswagen car. Same goes for Coca-Cola, and these carries goodwill and as well as assures the consumer of quality of the products. Now, benefits of trademarking your products: exclusivity. You exclusively use your mark for the number of years. Of course, also ensuring that you renew after the term expires. Also protects you against infringement. No third party can use your trademark legally, unless of course you waive your rights to protecting or seeking redress in the courts or writing letters to registry or trademark office. You're the only one that can use your trademark during the time of course your registration and during the subsistence of your term. And it's also a unique marketing tool. As I said earlier, companies like Coca-Cola depend highly on their trademark to sell their products. So when you go to the market and you see the Coca-Cola brand, you can tell that this is a Coca-Cola. You can tell a Coca-Cola product and a Pepsi product because of their trademark. It also safeguards trade and incorporated names. So for trademarks, companies can register their names in Nigeria, for example, with the Corporate Affairs Commission. But we all know that companies sometimes, in the course of business, start being known for a particular name, even though it's not what they are incorporated by. So you can have a company that goes by the name Olushola and Co. And what they know their products for is probably Olushe. In that scenario, they would have to protect the name that they trade by, even though that is not their incorporated name. So it's important for names that go beyond just incorporation and that are used in course of trade to be protected by trademark, and registering your trademark helps you protect that. It also gives you actionable rights against unauthorized use. I spoke about that earlier, where someone else tries to use your trademark symbol, name, or mark, you have a cause of action in court. Monetization through assignment and licensing as well. Yes, where you have your mark or your symbol trademark for someone else to use it, they can license it from you. You can assign it to someone else. It's also part of businesses. Sometimes when companies probably want to seek financing or borrow money, sometimes as part of securities for those investments, sometimes lenders seek for the assignment of certain trademarks during the term of the loan or until the end of the term of the loan. Yeah, it also builds trust. Trademarking your product also builds trust, protects again infringement, and also helps differentiate a product or a service from others. I made the example of Coca-Cola and Pepsi earlier. It helps you differentiate one product from another, and helps customers as well ensure that whatever product they're buying is actually the authentic or original product. Intellectual property licensing. As mentioned earlier, intellectual property licensing is also another way of generating revenue for intellectual property rights holders. They can give a third party license to use their intellectual property, be it patents or trademarks or copyrights, on their designs in other clients. As I said, sometimes a company might be located in a particular geographical location, but to spread their market reach new customers, as well as increase brand reach, they can license a third party to use their intellectual property, be it design or trademarks. And this is usually evidenced in a licensing agreement where the term of use of the intellectual property rights is specified, the purpose of use is specified in order to prevent a situation where the third party uses the trademark or the intellectual property right beyond the prescribed or the permitted forms of use. So the intellectual property right holder has the opportunity to limit how the intellectual property is used by the extent of use. There's also authorized users where the holder of the intellectual property can determine who uses or who trades or exploits his intellectual property. So it's not that he gives one person the right to use the intellectual property and then he's opened up use to the rest of the world. A good example of
Sorry, David. Sorry to cut in. Please, can you round up the presentation so that we can have feedback from you?
So, all right, okay. We also have intellectual property franchising, usually an agreement between legally independent parties, which gives a person or a group a right to market a product or use a service. I'll give an example with franchising. I'm sure we've heard about Marriott hotels in Nigeria. So our McDonald's hotel, McDonald's and restaurants, eatery. It's a good example of franchise. If someone wants to probably open a new McDonald's restaurant in Nigeria, he can reach out to McDonald's and reach a franchising agreement that allows him to open a new McDonald's shop in Nigeria. There are different types of franchising. This could be job franchising, which involves usually sole proprietor, maybe purchasing new equipment or product stocks and stuff like that. We have product franchising where somebody else sells products or distributes products and probably outside the demography of the intellectual property rights holder. We also have business format franchising, where someone can franchise the system of his business to someone else. A good example is fast food franchises and membership fitness centers. We have investment franchises as well, conversion franchises. An example of franchising is Jumbo Juice. In the early 2000s, Jumbo Juice began franchising intellectual property, and this led to it opening 600 franchises in different parts of the world. To start franchising in Nigeria, there are several regulatory processes to go through, but one of it would require registration, Corporate Affairs Commission, depending on what type of corporate body you choose to set up. Immigration, where it will involve a foreigner coming into Nigeria, registration with the National Office of Technology Acquisition and Promotion, especially where it involves importing technology. The Federal Competition and Consumer Protection Commission also will probably come in, where it will involve probably a merger or anything like that. Registration of the trademark as well, the trademark office in Nigeria, where it will involve using the trademark of somebody outside Nigeria, will also be important. I'll move quickly. Oh, yes. So, yes. Thank you.
Thank you so much, David, and well done to Group 1 and Group 2 for your presentation. You did a good job. And we want to give our mentors the opportunity to give their feedback. Ms. Shukurat has already done good justice to also review in her presentation. She also did a lot of reviews on the presentations on the two presentations that were made by the two groups. So we'll just be giving the floor to Ms. Bernice and Ms. Rita. I think they are still with us. Okay, yes, Ms. Bernice is still with us, and Ms. Rita is still with us. So we would like to hear from Ms. Rita and Ms. Bernice based on the presentations and what was sent to you, our mentors. What are your perspective, your thoughts, any contributions to what the mentees did on their presentation? Please, Ms. Rita, the floor is yours, ma'am. Ms. Rita, can you hear us? Are you with us, ma'am? Okay, if Ms. Rita is not with us, we would like to hear from Ms. Bernice.
Hi guys. I'll just say kudos to both parties. I think for next time, if a team has participants from more than one jurisdiction, then they should also give them the floor to be able to share their views as to how they understand the topic, and that may probably add more insights to their presentation. But well done to both teams.
Yes, thank you very much, Ms. Rita. Ms. Bernice, since she's no longer on call, Ms. Shukurat, please, do you still have anything to add based on the presentation that we made?
I don't think I have any addition. I believe I already made my contribution when I was presenting, except if we have questions.
All right, thank you very much, ma'am. Okay, Ms. Bernice.
Hello?
Yes, ma'am, we can hear you. Okay, Ms. Bernice is kind of hard, but I think. Okay, ma, are you with us?
I can hear you. Can you hear me?
Yes, ma'am, we can hear you now.
So I would just like to say, like I always say, I listened to a few of the presentation, and I'll say that as lawyers or people who would be lawyers, right, it's very important to take a very practical approach to IP, because I get it that we've listed out all these things and we've broken it down and we'll talk about it, but it's important for you to relate it back to the business. And from my experiences, you would have to think on your feet and apply this IP that you've mentioned to identifying them in the business. And I think that other mentors mentioned all of this. So you have to take a very, very practical approach. And I see that apart from registration, there are people who would be involved in the litigation aspect of the application of intellectual property in business. But the foundational aspect is where you would be as a young lawyer, and that's the registration and the contractual protection usually. So if you have to learn, or like I said before, the very first one is you have to quickly identify an IP agent. If you're working independently, if you're working with a law firm, they most likely will be accredited. You have to find a way to sort of like understand how registration works, because as you have an agent, right, you want to protect your IP, you also have to have a working understanding of, the various classes, especially the various classes, basically, because there will be a lot of arguments as to whether a particular trademark falls into a particular class. There will just be back and forth about that. And you have to understand what the law really says about those intellectual property before you can either raise your arguments or go back and forth. Because sometimes these IP agents are also not IP inclined. I don't want to say IP lawyers because they can also be IP experts, but some of them are not exactly as vast. So they're just using their experience, basically. But you might have some arguments with the law and all of those things. So you must understand how the registration works, because one of the various aspects that as a young lawyer you'll be confused about. Like, I'm hearing so much about intellectual property, but how do I participate? How do I get active in the field? Registration is like the core part of it. So it's either you do it by yourself by getting accredited, or you cling yourself to an IP agent that you trust, or somebody you look up to, whichever one, or a lawyer that already has such accreditation. Yeah, then also the contract part of it, right? One of the things people would not tell you is that you will be navigating a whole lot of IP assignment clauses. Now, not as independent contract, but as individual clauses in contractual agreements. So you have to understand the business of it so that you would know how you're going to draft your IP clause. If you just understand only IP itself, and I think that one of the mentors mentioned, if you just understand only the law itself, when it comes to application, you'll be lost, because all you want to do is assign all the rights or don't assign the rights. But where negotiation comes in is where you understand the business of it, and you understand that your party would have to let go of certain rights to receive a financial compensation, something like that. Like, I make reference to software development, for instance. That is where bulk of IP is transferred. So you have to identify who has what exactly are you, who are the third parties that has licensing to give you, what are the open source components you are looking at to give to your clients. So those are the things you would have to identify. So you have to understand how you can draft, redraft, and construct clauses in a way that favors your client and favors the other party, if you're trying to draft a contract that favors both parties, basically, or you're trying to protect your client itself, because you'll be acting as lawyers to either both party or one party. So you have to understand how you can tweak these clauses to favor you, because that's where you spend most of your time as a transactional or IP lawyer, aside just doing the infringement things. And of course, the people who are into infringement to tell you how it starts and how you have to file all those documentations, and those are like my contribution. But what I'm trying to say is that focus on understanding the various businesses versus IP and business, understand their models and how they work, understand how software as a service works, understand all of those things. Then you will now understand how, or the portion of IP that you are allocating to whoever you are allocating to. So that's what you need, the practical aspect of it when it comes to IP and business, not just the law itself. You can't treat it as in isolation, but you have to find a way to navigate those particular areas. So these are like my comments, right?
Thank you, Ms. Benis, for that wonderful contribution. Thank you to our mentors who have done a great job and a wonderful job. I want to see reactions from our mentees saying, well done and thank you to our mentors for putting us through this topic. And now it's time for question and answer. Okay, I saw a hand raised, and I would like to still call you on, Mr. Olisa, if I'm not mistaken. Your hand is raised. So please, you can go ahead and ask your question. And other mentees that also have questions, you can drop them in the chat box, and also you can ask them like.
Okay, good evening. Thank you. I don't know if you can hear me.
Yes, we can hear you.
Thank you. So, first, I appreciate the mentors and the coordinators for this platform. I was part of those who were trying to present, so my colleague was presenting. And
We can barely hear you. I can't hear you at all.
Oh, is it better now? Can you hear me?
Yes, it's a bit better now.
You are not loud enough.
Okay, thank you so much. So basically, the question I have is with regards to IP management. I would love to know the biggest challenges, even if there are challenges, how best can IP management, the challenges of the IP management, how best can they be
So sorry, Mr. Olisa, you were not very clear. Please, can you just rephrase or re-ask the question rather?
Okay. I said, how best can be properly
Type question.
Okay, Miss Bennis, did you hear his question?
No, I didn't. Just think that he typed it.
Please, okay, I would like to request, Mr. Olisa, if it's possible, send your question in the chat box so that we can clearly get or understand the question that you are asking. But then there's a question from Mr. Olusegun. His question is, how does one become a trademark agent? So I would like any of our mentors to jump on this question. How does one become a trademark agent?
I would like to answer that question, but I'll also answer that question with a question. So my first question is, how can you rate your knowledge of IP? I'm asking the person that is asking how one can actually become an agent, because you don't just wake up one day and say you want to become an intellectual property agent, because IP is not just on the face of it. There are other aspects of IP you need to understand. You should be able to like dissect and analyze before you can say you want to become an agent, except you just want to be an agent on the face of this, whereby you have to give your work to an other IP expert to do the work for you. So I'll advise you to calm down and understand the aspect of IP deeply. Then you can also keep going forward. You want to become an agent, but at this point, with this level of knowledge, I think becoming an agent shouldn't be priority right now. So I'll leave other speakers to also address the question.
All right, thank you so much, Ms. Shikurat. Does any of our mentors want to answer that question, or should we just go to the next question? Because I can see someone says he wants to answer, someone saying he wants to ask a question. Hello? Okay, Ms. Bennis, are you with us?
Yeah, I hear you.
Yes, ma'am. Please, do you want to answer that question?
That, like, once you have that, like, IP. I mean, that's why you're here, right? You think that you've gotten to the level. Then the portal is open. You can register on the portal. You can reach out to already existing agent, like I said before, or you can go to the trademark registry in Abuja, if it's possible, to, find out. Really, it's currently an open closed system, right? You might be lucky that your portal is approved online if you do it directly on the portal, or you reach out to an already existing agent who probably has contact to help you with that. Or better still, you can go to the trademark registry in Lagos, in Abuja, to get that clarified or something. So.
All right, thank you very much, Ma. We'll be jumping to the next question. Jess, please, if you said you want to ask a question, please can you go ahead and ask your question? Okay,
I
before
hope you
Jess
get it.
asks, okay, we can hear you.
All right. Okay, so thank you to all of our mentors. I want to ask a question related to something like a publication, like we were talking about intellectual property. I remember once in my country, we had this journalist who he wrote an article, very interesting one, and he made a publication of it. But someone went and copied the article and pasted it on his own page without giving credit to the original person who wrote the article. But then now the issue came about with this issue of intellectual property protection, having whether your property is not being protected by any IP or anything related to it. So I want to know, in cases like that, if that person who is the original owner of the property, I mean, can gain at least one or two maybe right as a result of damages. I hope you got a question.
Okay, thank you so much, Jess, for that question. Miss Rita, please can you help us with that question if you got what Jess said? Miss Rita, are you with us? Okay. Sorry, Miss Rita, we can't hear you.
Oh, I said I didn't get the question properly. Can you take the question again? Let me answer.
Yeah,
Okay,
yeah.
Jess, please. Okay.
Yeah, I'm going to repeat. My question is this: that there was a journalist in my country. He wrote an article, on certain training issues, and when he posted the article on his personal page, on his social media page, it gained a lot of attention. But then someone went and took the article as well and posted on their own page without giving credit to that person. But then the question came about with this issue of intellectual property protection. If maybe the property is not being protected because he was just doing something like freelancing. So my question here is related to the issue of damages. If maybe the original owner of that property has right, so with the exception of protection where he has no protection over the property, like no copyright, like no, like you were talking about patent and other things, if the person can still go in for damages.
Okay, so your question is regards publication online. I believe when I was talking about copyright, I made mention of takedown proceeding as an alternative to resolving certain disputes. Also, for such scenarios, you would have to take into consideration the terms of use of the social media platform. What does the IP clause state, and how can you resolve such dispute? If the person plagiarized, because that's basically so it's like a thin line between plagiarism and infringement. Plagiarism will tilt more towards academic publication. Infringement will tilt more to IP related unauthorized use of IP works, which in this case will be online. So it's one copied and pasted your publication without acknowledging you, then there's an infringement, then there's a plagiarism case. So you can report that post and deal with it, go through the social media platform dispute resolution alternative that they have there and find a way to resolve. The post will be taken down. For other works such as musical works, I think YouTube also has procedures for that. Under the Nigerian law, we have a takedown procedure. We also have what is called a protective wait, protection, sorry, hold on. Technological protective measures, whereby if you go the extra mile of maybe using a watermark to protect your work and someone removes the watermark and reposts or redistributes or republishes the work without without your consent. There are measures that you can explore under the Nigerian Copyright Act. Since this is more of a copyright question, I'll focus on the copyright element, but then again, you need to understand that copyright as an IP is automatic. However, some jurisdictions explore the voluntary depository method, while some require that before you sue for copyright infringement, you must have registered the work in question. So the laws applicable in your jurisdiction will guide you. The laws applicable to the social media platform will also guide you. And then also, in conclusion, speak to a copyright lawyer or a firm that specializes in copyright to guide you on how to resolve such disputes. Social media callers will only do a bit, you get dragged for a couple of days, but the post is still online because you haven't resolved it. So I hope that answers your question. Jess, does that answer your question?
Yeah, I got it. No problem.
Great.
Thank you so much, Mrs. Rita, and also thank you, Jess, for answering that question, for asking that question. We'll still be taking live questions before we go to the question on the chat box. So, David, please, you can go ahead and ask your question.
Yes, good evening. So my question to our mentors was, in a case where you have a client that has like an investor, or maybe an investor probably wants to provide financing or wants to invest and wants the IP of your clients, how do you value intellectual property? Do you have like independent valuers come value it, or how do you like place value on know how much the intellectual property of the client is worth, especially where the client is going to be assigning his intellectual property? Thank you.
Okay, thank you so much, David. We'll be directing this question to Ms. Shukurat. Please, if you can you help us answer this question?
Okay. So your question is majorly focusing on IP valuation, right?
Yes.
Okay. So I would say IP valuation is like a different aspect of IP on its own, because at this stage where we are right now, people are still trying to buy into the idea of IP, right? And people don't see IP like the way they see other aspects of tangible assets. So valuation is a bit dicey, but some people use cost-based method, market-based method, and there are some actual, I think there is this particular group, is it ESP also? I think Rita can help with that. I can't remember the name of the group actually. They do intangible asset valuation. But like I said, intellectual property is one type of intangible asset. So one way or the other, they also do valuation for intellectual property. So it depends on the method you want to use for your valuation. But like I said, the value aspect of valuation is a different thing entirely, because it's not what we are into presently in Nigeria. It's still kind of dicey, not so known aspect. So you can't really say this is what to do. But once you stay in that aspect and you keep okay, I think Rita shared a link now.
Okay, hello, ma. Miss Shukurat, are you still with us?
Oh, I was muted. Sorry. Okay. So Rita just sent a link now. You can check the link. I think she has some information on IP valuation. You can go through that link and listen to the podcast. So I think that will help.
All right, thank you.
Thank you so much, Ms. Shukrat, and also thank you, Ms. Rita, for sharing that link with us. So our mentees, you can go ahead and click on the link and also go through it so that you can get to know what IP valuation is and have the necessary awareness that you need. All right, so we'll just be taking the last question. Okay, I see a hand raised. Please, whose hand is raised? Okay. Still, let's go to the question in chat box. The last question, and it's please, how can the challenges associated with intellectual property management be properly addressed? Ms. Amosa has addressed the issue of IP valuation, so we'll just be sending this question over to Ms. Rita to help us with it. How can the challenges associated with intellectual property management be properly addressed? Ms. Rita, are you with us?
Yeah, you said how
Can
the
challenges associated with intellectual property management be properly resolved, properly addressed rather? How can the challenges associated with intellectual property management be properly addressed?
well, I think to answer that, I would just say first you need to do your due diligence. That will determine the strategy that you would use to resolve whatever challenges that you're roaming around in where the issue is, addressing it as to say with regards to that, resolving such dispute. What are the risks involved? What is the impact? And the way forward. Are you going to renegotiate, or are you going to tilt towards what the other party may be interested in? If it's a cross-border related issue, how do you resolve it? What will be the governing law, etc., etc.? So that's like the long and short of it. IP management is like is more than a 2-hour conversation. So I hope that answers the question. If it doesn't, maybe some other panelists can share their views.
All right, thank you very much, Ma, for helping us with that question. Jess, you still have another question just before we round up this session. Jess, are you with us? Do you still have another question? Okay, if there are no more questions, I think it's good. It's okay if we call the session draw the session to a close here. I want to say a big thank you to our mentors once again for those present and those in essential. Right, they have really, really done so much to bring us to this point where we've learned quite a lot as regards this topic. Right, I want to see our mentees react, show their emojis, send messages in the chat box saying thank you to our mentors for a job well done. Thank you for your time. So thank you for your time. Thank you for sparing your knowledge and also choosing to share it with us. With this, okay, yes, before I forget, we have not taken our pictures yet. So please, can we have our mentees turn on their camera once again? Right, and also please, if our mentors can, I would also like to plead for our cameras to be on so that we can take a quick picture and then call it a day. Okay, please can I see more mentees turn on their video? Okay. Just a little time, just a few more seconds and we'll be done. All right, thank you so much to everyone who made it to class today. Thank you to our mentees, thank you to our mentors. Please, I would like to request our mentees to kindly follow our mentors on all social media platforms. If you want to have access to this particular class, it's on YouTube. You can just click on JIIPCC, and then you have access to the class. It's recorded. You can just type on intellectual property for business, and this class will pop up. So thank you so much to our mentors once again. And with this, we've come to the end of today's session. We look forward to having our mentees present in class again for next week. And we also look to have our mentors in other sessions. So thank you so much to everyone, and good night, everyone.